Good afternoon, everybody. I'm Peter Ahrens. I'm the Executive Director for the Buffalo Niagara Manufacturing Alliance. I'm joined here today by Brad Hoppy, who is a partner with Bond, Schoeneck King. And of note, with Bond, Schoeneck King, they're also a strategic partner with the BNMA, which we appreciate their level of commitment to manufacturers and manufacturing in Western New York. If you have questions throughout the presentation, please type them into the message box and Brad will address them at the end of his presentation. But without further ado, Brad, take it away.
Thanks, Peter. And, we're obviously Bond, Schoeneck King. We're a proud partner of the BNMA. It's a great organization, and we're happy to be involved in the capacity that we are. As Peter noted, my name is Brad Hoppy. I chair the manufacturing group here at Bond and am a member of the litigation practice group. My emphasis is on trade secrets and non-competes. In addition to my litigation practice area, I counsel clients routinely on ways to protect their trade secret information, including through the use of non-competes. And that's what I'm going to talk to you about today a little bit. The threat that's posed by your company insiders and principally your employees to your trade secret information. So I'm going to go ahead and share the PowerPoint presentation with you, and then we'll go through it. All right. So I'm going to cover four main topics with you today. The first is a very high-level overview, the basics of trade secrets. Then we're going to get into the Defend Trade Secrets Act of 2016. This is a federal legislation that's very significant and provides certain remedies that weren't otherwise available under New York law. After that, we're going to get into theft prevention, so ways to prevent trade secret theft in the first instance. And finally, theft mitigation and the steps that you need to take in the event that you suspect or you learn of a trade secret theft. Before getting into the threat, let's talk a little bit about the basics of trade secret law. As you can see from this slide, a trade secret can take numerous forms. It can be your secret sauce, it could be a secret formula, it could be a manufacturing process, or it could be a compilation of valuable information. And I think the best example of that, is a customer list. And every manufacturer, every company, has that customer list, listing out all their current or prospective customers. But the thing about a customer list is, I think a lot of people assume that's considered a trade secret under the law, but that's not always the case. Kind of the example I give when you think about a customer list is a telephone book, and a basic customer list and a telephone book really aren't that different. A telephone book has your names and telephone numbers of a bunch of individuals. A list without anything more is not that much different, and in most circumstances, that kind of list is not going to get you trade secret protection. That being said, there's a way to turn a customer list or even a telephone book into protectable trade secrets under the law. And the way you do that is you start adding competitive information that if it falls in the hands of a competitor, certainly can do you harm and have a lot of commercial value. Some examples, if you add, in addition to, the name of the customer, you add the, representative, the individual that you have a relationship with. You add that person's name. You add that person's telephone number. You add that person's email address. You start listing out the prior sales to that particular customer. You add the requirements for that customer, not only what they're buying from you now, but what they may need in the future. You add that to the pricing, not your general pricing, but customized specific pricing for that customer. Before you know it, you have what is similar to a telephone book. It's transformed into an extremely valuable piece of information. And as long as you keep that valuable piece of information secret and out of the public domain, the law will protect you and protect that information and help ensure that it doesn't get released to the public and used against you in an unfair competitive manner. Now, what is a trade secret? All right, well, here's the rule in the state of New York. A trade secret is any formula, process, device, or compilation of information that's used in one's business, which confers a competitive advantage over those in similar businesses who do not know it or use it. This is lifted straight from the restatement of torts, and it's been memorialized in the law of New York through various cases throughout the year. It's actually unique, something unique to the state of New York, that we apply a rule like this for trade secrets. Every other state in the country has adopted a variation of what's called the Uniform Trade Secrets Act. The only holdout in the country right now is New York, which applies this standard that looks at a bunch of different factors. And these are the factors that a court in New York considers in determining whether your information is entitled to protection under the law. Now, there's a lot here. There are a lot of nuances, and we really don't have time to go through all that. But the most important elements, the most important things that a court is going to consider in determining whether or not your information, what you want to be protected, actually does get protection under the law. And those two factors are whether or not the information is commercially valuable, and number two, whether or not you have been able, well, you take measures to and actually succeed in keeping that information secret. And that's what we're going to talk about today, the second part of it. How do we keep that information secret so it maintains its protection under the law? But before we get into that, just a few more things I want to touch upon. And the first is the difference between a trade secret and a patent. This is one thing that when you're developing certain information, you need to make a decision on, because you can't get both. It's a choice, one or the other. And there are pros and cons to both of these. Going through the process of patenting certain information, certain inventions, or relying on trade secret protection. Now, the pros. Trade secrets have no limitation in time. They could last in perpetuity, whereas a patent may only last up to 20 years. You don't have to go through that a costly patent approval process that takes a lot of time. Trade secrets are immediate. The moment you develop that information, and you keep it secret, you get protection under the law. So it's unlimited in time. There's no need to register it, and protection is immediate. All of that is great. There are some downsides, though. You don't get a monopoly. Once it's made public, anyone can use it. So, if you have a situation where you're unable to keep your information protected, you're unable to keep it out of the public domain, someone's able to reverse engineer it, you lose that protection. So it's vitally important, if you choose the trade secret protection route, that you take steps necessary to ensure that information stays secret and out of the public domain. All right, and this is just a brief recap. We went over all this. Trade secret is non-public intellectual property. You don't get a monopoly. It lasts indefinitely. And if disclosed, independently found or reverse engineered, your rights disappear. All right, so I've included in the slides a discussion of a good case, I think, that illustrates some of the things that you really want to avoid if you want your information to stay protected under the law, and you want a court to step in if need be to provide you that protection. Now, Delta Filter acquired a company that specialized in HEPA filters. The employees, including the defendant in the case, came over as part of that acquisition. The defendant then became responsible for Delta Filter's new HEPA filter division. He leaves the company and starts a new company, brings others with him, and then basically takes what he learned at Delta Filter and does the identical thing on behalf of the company that he forms. Now, this sounds like a classic trade secret, unfair competition type of case, but the court saw it differently. The court looked at a couple factors, looked at what was being duplicated, and determined that it could be done without the use of blueprints or photographs or other physical documents. This is something that the former employee simply could do through his memory. And there wasn't a non-disclosure agreement. There was no agreement whatsoever, no non-compete, no non-solicit, no non-disclosure. The court looked at what Delta Filter did, other steps it took to protect its information or not to protect its information, and found that Delta Filter routinely let people in to inspect and just take a look at its filter production process. And again, doing it without the use of non-disclosures. Now, based on these facts, even though the competitor used that former employee to develop the identical filter system, the court held that in the absence of any secrecy agreement preventing defendants from using the technical knowledge which they naturally and legitimately acquired during their employment, the credible evidence does not support any inference that they used improper means to acquire the information or that such means were necessary to do so. The court further held that the actions were as consistent with the normally expected desire for fair economic self-improvement as they were with a well-planned, well-concealed conspiratorial attempt at industrial piracy. Now, the main takeaway from this case is that if you do not do things, you do not take the steps necessary to protect yourself, you cannot expect a court to swoop in and provide you that protection. You need to take those steps or it will be held against you. And Delta Filter is just one of many cases that have come to that conclusion. All right, just to, I guess, shift gears a little bit here. Trade secret theft, a growing problem. I mean, everyone here has heard of the cybersecurity threats that are out there, whether they be from hackers or foreign powers. And Jessica Copeland from my office, I know, did a webinar on cybersecurity back in February. It's obviously a huge problem, and there's a lot of publicity about it. But I think a lot of that publicity is at the expense of a threat that's really right under your noses. And that's the threat that's posed by your trusted employees, the threat that's posed by your partners, the threat that's posed by your independent contractors, the people who, as part of their normal job responsibilities, are given access to your most vital information. And that threat's every day. If it's not managed properly, it could be really catastrophic to your company. Now, if you look on this slide, the last thing on here, accidental disclosure. Take a look at this next slide. I mean, I think it's kind of humorous, but I think it makes an important point. If you don't have policies in place at your business, if you don't have buy-in from all of your employees with respect to the protection of your information, it doesn't really matter what you do, because things like this can happen, and they could happen on a routine basis. Simple carelessness, someone opening up their laptop on an airplane and doing work with confidential and trade secret information while anyone can see it. This is common. This happens. And something like this, if that person next to you looks at it and, sends a tweet out or, sends out a text message, that information that's on that laptop can be released to the public and you could lose your protection. So this is why it's important that policies and procedures are in place so employees start to think twice, before they act in a careless manner, because the loss of trade secret information isn't always about malfeasance. A lot of times it's just about simple carelessness and negligence. All right, how theft is accomplished. This is obviously not an exhaustive list, but these are some of the things that I see routinely in my practice as a trade secret litigator and as someone who counsels clients on ways to protect their information. The use of thumb drives. They're still used quite a bit by employees in the lead up to termination. But it's not just, again, malfeasance here. A lot of employees in violation of company policy routinely use thumb drives to take information, bring it home, work from home, work, while traveling, and they forget to return it at the close of employment. You need to have, appropriate training of your employees to ensure that at the close of employment, whenever termination is, the ask is made for them to return all information in their possession, including thumb drives. But this is also a way that theft is accomplished through malfeasance. You see it all the time. They plug it in, they upload information to those thumb drives, and they walk out, sometimes with your most valuable information. The next one, uploading data to the cloud. This is one that we've been seeing more and more of. Frankly, it's pretty scary. I like to call the US or the cloud accounts now USBs in the sky. And I call them that because once you upload information to a personal cloud account, that information can be accessed by any device anywhere in the world, and it becomes virtually untraceable. And that's scary. Because if that's done, there's really no way to find out where it ultimately went, and it's out there and it's in the public domain, and there's not much you can do to unwind that. The next one, transferring data to a personal email account, we still see that all the time. The employees 2 days before they leave, going to a competitor, they just send a few competitive emails relating to project proposals or emails, showing contact information for certain people over to their personal email account so they could access them on day one on behalf of that competitor. And these last 2 points on this slide, these are statistics from recent studies. And this goes back to the idea of carelessness and negligence. On these studies, employers, 24% of employees they said that they still had network access after they had left their prior employer. That's scary. That should never happen, but it does. In that same study, 82% of employers, even when they had reason to look, did not review what documents and data that former employee may have taken. Again, these are things that you need to do routinely when an employee leaves. All right, so I think it's pretty clear based on what you've seen that the threat is real. But here are some stats to back it up. And the first point here, you can see the cost of the U.S. economy is just staggering. And the problem is growing, as you can see from the frequency of cases. They doubled from 95 to 2004. They continued to increase after that. After the Defend Trade Secrets Act was passed in 2016, they increased. And even during the pandemic, trade secret cases have remained steady. Even more startling are the stats on this slide. This first one in particular, nearly 60% in a survey admitted to stealing company data. And of those, 67% admit to using that data in subsequent employment. And even scarier, these are the honest ones. I mean, what are the real numbers? If 60% of people admit to it, it's probably much higher. And then as you can see these next 2 points, kind of what I said earlier, theft is accomplished by employees and insiders. And I think these stats make that abundantly clear, both in state court cases and in federal court cases. Simply put, I think if it hasn't happened to you, then you're very lucky, but you need to prepare as if it will. All right, the Defend Trade Secrets Act. As noted, this was passed in 2016. It's a significant piece of legislation. The federal government finally recognized the threat and did something about it. And actually a very rare showing of bipartisanship. It actually passed the Senate unanimously. And what it does is it provides substantial remedies for trade secret theft that aren't otherwise available under any state law. And that's important. And we're going to talk about those right here. All right, so anytime you have a theft of your trade secret information, what you're looking to do in a case is stop it. Stop the use of that information and get it back. In the typical process, if you could show actual theft, you would get a temporary restraining order or a preliminary injunction. That's available under state or federal law. But one thing that's a little bit different under the Defend Trade Secrets Act is that it provides for ex parte seizure with respect to both the trade secret and any device or document that may contain that information. And by ex parte seizure, what I mean is, without having to notify the other side, a court can order that a sheriff go out to a place of business and seize all devices that may contain that trade secret information. When this statute was passed, that was eye-opening. That's not something that we had seen under the law in any state law, for a remedy for trade secret theft. As it turns out, looking back now, it's been 6 years. This isn't used very often. It's the exception, not the rule. You need an extraordinary case to do it, but the fact that it exists, I think, is itself significant. But that's not to suggest in any way that the statute doesn't have real teeth, because it does. It provides for remedies that are unavailable under New York state law. such as double damages and attorney's fees in the event of a willful misappropriation. So, just I guess to understand that a little bit. So if you can show that an ex-employee and a competitor worked together in a malicious way to steal your information, and as a result, you lost $500,000 worth of business. Under this statute, you'd be entitled to $1 million in damages, plus whatever fees and costs you incurred to prosecute that case. And anyone who's been through a misappropriation case knows how expensive that is. So having the ability to recover your costs and fees, that's a big deal. And finally, the statute provides for whistleblower immunity for anyone who discloses a trade secret under very limited circumstances, whistleblowing type circumstances. Now, there's one big caveat to getting all of these remedies under the Defend Trade Secrets Act. And that is that you need to include in all agreements with your employees and contractors what's called a whistleblower immunity provision in a very specific form that's required by the statute. And the agreements, and that too that's been construed pretty broadly under the statute. It includes, not only your employment agreements, your non-disclosure agreements, your non-competes, but also even your employee handbooks. So basically anything you have with an employee or a contractor that contains a non-disclosure confidentiality provision, you need to make sure it includes the whistleblower immunity language. But it is very specific. And if you don't hit the words just right, it won't be given effect. So that's something that we certainly recommend that you reach out to an attorney if you don't already have it, to make sure you have that in your agreement so that you can get the benefits of this statute. Just briefly, the differences between the Defend Trade Secrets Act and New York law. As I noted, New York does not provide for the double damages or the attorney's fees. You don't get that ex parte seizure under New York law. And then Defend Trade Secrets Act actually does have a broader definition of trade secrets than does New York, which is, I think, in certain circumstances is significant. For example, under New York law, any information relating to a product that was developed but didn't go to market, kind of a failed product, New York doesn't view that as commercially valuable, so it doesn't get trade secret protection. Under the Defend Trade Secrets Act, that information, if kept secret, is oftentimes worthy of protection. So that can be significant. Just briefly, conclusions on the Defend Trade Secrets Act. The remedies we talked about, need to make sure that you have that whistleblower immunity language in your agreements with employees and contractors if you want to get the benefits of the statute. And finally, this last point, pros and cons of state versus federal court. This is always a consideration when you're dealing with a misappropriation case. Where do you want to sue it? What we've seen, since the passage of the Defend Trade Secrets Act is that federal courts are very receptive to these claims. You also get more predictability in the way the rules are applied. So I personally, I'm a big fan if you have the opportunity to take these cases to federal court. All right, so we spent some time on the law of trade secrets and the damage that trade secret theft costs the economy and businesses throughout the country. Obviously, it is a serious issue, but how do you prevent it in the first place? Well, I think first and foremost, you need to be proactive when it comes to your trade secrets. We as attorneys see it all the time. A lot of clients would rather bury their heads in the sand and hope that it will not happen to them. But the statistics say that if it hasn't happened already, it most likely will in the future. So you need to be prepared. And the way to do that, and what we recommend you do, is to perform a trade secret audit at your business. Audit the policies and the procedures you have in place for the protection of your information. Provide necessary and appropriate training to your team. One example of that is how you deal with employees who are coming in and how you deal with employees on their way out. There's best practices for all this, and we highly recommend that you make sure people are trained on those best practices. We recommend a trade secret protection plan that's unique to your business, that memorializes your policies and procedures for trade secret protection. If you don't have agreements in place, your non-disclosures, your non-competes, your non-solicitations, we highly recommend that you have them in place. And if you have them and they're old, you need to update them periodically to ensure that they comply with the law. The idea here with a trade secret audit is to create a culture of protection at your business and to obtain buy-in from management all the way down to lower level employees. So you don't have that situation we went over a few minutes ago with the careless employees or something being missed as part of the employee departure protocols. Everyone's thinking about this all the time because they understand the risk, not only to the business, but to them of the loss of trade secret information. Now, with respect to policies, here's just a few of them that we recommend that you have in place. The first, the memorializing the secrecy policy, that's your unique trade secret protection plan. Restricting internal access to trade secrets. Make sure that if an employee doesn't need to see it, the employee doesn't see it. It should be on a need-to-know basis. The cloud, you shouldn't have employees being able to access personal cloud accounts through company devices or on company time. Limit or eliminate that. Use cloud accounts that are under the control of the company, not the employee. Physical security, only employees that need to have access to your physical documents that contain trade secret information. Make sure, things are locked so they can't. Labeling things properly. It means something to put confidential on your documents. It means something to put trade secrets on your documents. It makes clear to anyone what this is. Computer secrecy, going back to restricting internal access. Making sure that employees with unique login credentials can only access what they need to access to do their jobs. Public accessibility. If someone's coming into your business, make sure that there's an NDA signed so that they can't just sit there and report back to anyone they want what they saw. And finally, this last point, dealing cautiously with third parties through the use of contracts. And the contracts we're talking about when it comes to trade secrets, I mentioned them already. Your non-competes, your non-solicits, and your non-disclosure and confidentiality agreements. Now, that's been a common thread. I've mentioned the use of contracts numerous times. And the reason I have is that, your contracts, your restrictive covenants can be either the best or the worst means to achieve trade secret protection. And by that, I mean this. If you do it right and you ensure that your agreements, your restrictive covenants, comply with the existing state of the law, and they're tailored to the particular employee at issue, then it is a powerful tool at your disposal. You stand a very good chance of that agreement being enforced. If, on the other hand, you simply recycle old agreements, or you try a one-size-fits-all approach, then the agreement will not be worth the paper it's written on. And it's actually worse than that, because it gives you a false sense of comfort and security when in reality, the agreement stands very little chance of enforcement. And remember, this is an area of the law where, employees are gaining more and more knowledge. They're educated when it comes to non-competes. They talk amongst their friends. A lot of them have retained counsel to look at them. They know when something on its face is overbroad, and they know what that means. So that means you need to work harder to make sure your agreements are consistent with the law and evolve with the law. And that means updating them as necessary. All right, so why do you want these covenants, these restricted covenants? Well, protecting trade secrets and confidential information, that's a big part of it. And that's why you use your non-competes and your non-disclosures. Protecting the goodwill and customer relationships, that's a big deal as well. You certainly don't want one of your sales employees who has developed relationships with your customers at your expense, going out there and exploiting that goodwill they develop the moment they leave and moving that customer to a competitor. That's why you have a customer non-solicit. Provide remedies that aren't available under the common law. The idea is you want to create a deterrent. You want an employee to think twice before taking your information or before violating the terms of those covenants. So, the types of provisions that we recommend you include in your restrictive covenants include, the Defend Trade Secrets Act whistleblower immunity provision. You want that in there. You want provisions in there for attorney's fees and costs, not just fees, costs too. Anyone who has been through a trade secret case knows, once you have to retain a computer forensic specialist, those costs are almost as bad as attorney's fees. So you want a provision in there that allows you to recover those costs as well as your fees. You want provisions in there for liquidated damages or the return of compensation paid during periods of disloyalty. You also want provisions in there for injunctive relief. You want all this in there, not only to provide a deterrent, but I think all of this also shows a court, that you're taking your trade secrets seriously. You assign a lot of value to them. That's why you do these things. That's why you have these agreements in place. That's why you perform this trade secret audit. And a court needs to see that if a court's going to grant you relief. All right, with that, let's move on to the standard for a restrictive covenant. How are you going to better ensure, or at least understand, whether or not your covenant stands a chance of enforcement? Like any contract, it must be supported by adequate consideration. There are no bright line rules. There never is when it comes to non-competes. But generally speaking, courts have held that the initial hiring of an employee is adequate consideration for a restrictive covenant. How you present that agreement, though, can determine whether a court ultimately enforces it. And here's just one example of that. If you drop a non-compete or a restrictive covenant of any type on an employee's lap on day one without giving them a chance to review it ahead of time, that's going to be problematic. A court will view that as evidence of coercive tactics, and a court could use that to invalidate the covenant. What you want to do is provide that non-compete, at least notice of that non-compete, to the employee in advance. I would recommend you do it as part of the offer letter. And I think it's even better if you provide a copy of whatever restrictive covenant you want that employee to sign as part of it. Not just put them on notice, but give it to them. That allows the employee to spend some time looking at it, consult with an attorney if necessary. And what it does is it deprives that employee of the ability to argue later on that they were coerced into doing this, or they didn't know what they were signing. So that's something that we highly recommend you do. The next on here is continued employment. That's also sufficient consideration. And what I mean by continued employment is telling an employee that, if you want to stay here, you need to sign, this reasonable non-compete. Courts have held that that's fine. You can do that, but it only works for at-will employees. And if you keep that employee for a sufficient period of time. While this is okay, it is the most disfavored approach. So you need to be extra careful when you're relying on continued employment. So don't get greedy. You want to make sure your covenant isn't overbroad or trying to get too much. The next two, promotion and severance. That's additional consideration. That's sufficient to support a reasonable non-compete. And finally, termination for cause versus without cause. The issue of consideration comes up when you're attempting to enforce a non-compete after terminating an employee without cause. There's a split in authority in the state of New York as to whether or not a without cause termination invalidates the covenant for lack of consideration. That actually was the rule, at least how things were understood up until 2014, when a case that started here in the Buffalo area ultimately held that a without cause termination does not invalidate the covenant. So right now we're in a situation where, depending on where you live in the state, termination without cause could invalidate the covenant, or the covenant could be fine. Western New York is that one spot where it's fine. But this is an unsettled area of the law. So our highest court will have to resolve that split in authority at some point in the near future. And the last thing here, more is not better. I think that a lot of people believe that if you just give more, you could get broader restrictions, and that's not really how it works. All that matters with your restrictive covenants is whether or not the consideration is sufficient. And if it's sufficient, then the reasonableness analysis we're going to go over here in a minute is what's going to apply. All right, and here's that standard. The covenant must be reasonable in time and area and no broader than necessary to protect legitimate interests. All right, there's a lot there, so let's unpack it. There's no bright line rule when it comes to duration. 1 year is almost always okay. 2 years, usually okay, not always. Anything beyond that, you're certainly at risk of having an overbroad covenant. Geographic area, that's going to depend on your business. That's going to depend on the employee. So if your business has a local reach, then your non-compete better have a geographic reach that's similarly local. However, if your business is statewide or national in scope or international in scope, and you have an employee that's responsible for a broad area as part of his or her responsibilities, then you could have a much broader geographic scope. This next point, legitimate interests. There are three that are recognized by New York law. The first, again, while we're here, trade secrets and confidential information. The second is the goodwill and customer relationships we talked about a few moments ago. But keep in mind the language in the standard above, no broader than necessary. Courts in this state have held repeatedly for the last 15 years that a non-solicitation covenant that applies to all customers, as opposed to customers with whom the employee developed a relationship, is overbroad as a matter of law and will be stricken. So to the extent that you have that broad covenant in your non-solicits, you need to update it and make sure that it complies with the law. The last here, key employees. These are employees who provide unique services or have some sort of special or unique skill under the law. It's mostly reserved for professionals, but under the right circumstances, it can extend to others. However, one thing that the law is clear on is that a good salesperson never qualifies as a key employee under the law. And finally, I do want to make note of what's at the bottom here. The abusive use of non-competes can result in an investigation by the AG's office. I know a lot of people here have probably heard of the Jimmy John situation where all drivers, delivery drivers had non-competes. WeWork had something similar where lower level employees were all locked up with non-competes. This is something that's on the AG's radar. If you use non-competes with lower level employees and there's no legitimate interest being served, expect an investigation. And the last part of the test, it cannot be harmful to the general public and or unreasonably burdensome to the employee. We went over the reasonableness test. If you satisfy that test, you're not going to have an issue with undue hardship. As far as the public policy, that usually only comes up in a few situations and usually in the professional context. So it's not going to be a problem, typically, so long as you satisfy the other parts of the test we just went over. All right, so you know the test now. Let's assume that you have an employee that leaves, takes employment with a competitor in violation of the non-compete, and who knows, maybe even take some information with him or her on the way out. That employee either brings an action for declaratory judgment to challenge the non-compete, or you as the former employer bring an action for breach of contract and seek whatever relief, an injunction, damages, whatever. The court looks at your non-compete and determines that it's overbroad in some respect. Well, what happens? Well, there are two options. The court will either partially enforce it or invalidate it. Here's the first one. This is when you're lucky. The court will strike only the overbroad portion and enforce the remainder of the agreement consistent with the party's intent. This is what the courts used to do in the state of New York. It's called partial enforcement. The other option, it's the nightmare scenario. And this is the trend. This is what we're seeing more and more of in the state of New York. Courts will not give employers the benefit of the doubt. Courts will not partially enforce the covenant. Instead, the court will strike the entire covenant, the non-compete or the non-solicit, whatever's overbroad, and potentially, by doing so, leaving your trade secrets and your customer relationships exposed without any contractual protection whatsoever. Like I said, this is the trend in the state of New York. It's to strike, not to partially enforce. So you need to make sure that your agreements are consistent with the law. And if they're old agreements, you need to update them. You need to have them looked at periodically so you don't end up in this situation. But there's no need to panic. That's what's great about it. You can still fix your agreements. And the way you can fix your agreements is by periodically reviewing them and updating them to ensure that they're complying with the law. And the way you can do that, and if you can notice that this is a very similar slide to one you saw earlier for consideration. It's doing the same things. You could condition someone's continued employment on a new non-compete, something that's probably going to be narrower than the first one. You could condition a promotion on execution of a non-compete. Any change, positive change in the conditions of employment. Someone's getting a raise. Well, condition that raise on a new non-compete or a new non-solicit or a new non-disclosure. And certainly if you're giving someone severance, if there's a separation agreement where they're getting money in connection with their termination, you should definitely be using that to your advantage, and make sure that whatever, covenant you had in place with that employee is buttoned up, and that severance is conditioned upon a new non-compete, a new non-solicit, a new non-disclosure that comply with the current state of the law. And before we move on to the next topic, I do just want to briefly touch upon some recent developments when it comes to restrictive covenants. Several states have restricted or eliminated them. California is the example I think most people know about, where by statute non-competes are barred. Other states like Oklahoma have followed suit. Other states, several in the Northeast and out West, have limited the use of non-competes and basically placed a salary number on it. If an employee makes less than X amount of money, you can't use a non-compete. I mean, that is the trend. New York hasn't followed suit. New York has introduced legislation at various times over the last couple of years to try to do this. It doesn't go anywhere, at least when it comes to non-competes. New York is more pro-business than many other states, so I don't expect that to change at any point in the near future. I'm sure most of you know about President Biden's executive order. This was a campaign promise of his, so it really wasn't a surprise when it happened. I think the most noteworthy part of that executive order is not really what it does, but what it doesn't do. It does not eliminate or even limit the use of non-compete agreements. What it does is it uses wishy-washy language, such as encouraging agencies to curtail the unfair use of non-competes. So it may signal some future limitation on the use of non-competes, but I do not expect that it's going to operate as any kind of bar of non-competes. And certainly I would think, and I could be proven wrong, but my expectation is that whatever comes out of this is going to be similar to those states that limit non-competes for lower level employees. We'll see. But certainly if, whenever something new comes out from those agencies, you'll be seeing something coming from Bond, Schoeneck King on it, just letting you know the significance of whatever comes out of the agencies. But I think it is important to note, in the meantime, until we see anything from the federal government, state law applies. So state law across the board, with a few exceptions, New York included among these states, will still enforce reasonable non-competition agreements. So make sure your non-competes are in compliance. All right, so let's assume that you've done your trade secret audit. Let's assume you've updated your restrictive covenants. You've done everything you need to do to protect your information. But you have a smart employee, an employee that knows what they're doing and is extremely motivated to get your information. And they succeed. They get something, but you find out about it quickly because you had your trade secret audit done and you discover it fast. What do? Well, first you need to contact us. If not us, some attorney, because this is not something that you can do on your own. An attorney will walk you through what needs to be done to protect your information, to locate and to secure relevant evidence, and to protect your legal rights for future litigation. If you haven't been through this type of situation before, when someone steals something, in all likelihood, you're not going to get it back, no matter how nasty the cease and desist letter you send is. You're probably going to have to go to court, and you have to operate under that assumption. And because of that, because what you're going to ask the court to do is likely going to be some sort of extraordinary relief where the court enjoins that former employee or even a competitor from doing something, you better act quick when you do it. And here are just a few things that we recommend that you do and you do fast. The first is to ensure that all devices are preserved. And by that, I mean your computers, laptops, smartphones, any device that former employee used. And you need to set them aside in a secure place. Do not, and I repeat, do not put those devices back into circulation. That compromises the data, it destroys chain of custody, and it'll negatively impact your ability to prove your case. I've seen it a lot of times. Cases are lost before they even start because the evidence that you need resides on a device that now is gone. So make sure you don't make that mistake. And I think it's important to note too, that just because you put it in a secure place doesn't mean it has to sit there forever. We use computer forensic specialists to help out on these cases. They'll image those devices. And once those images are completed, at that point, your devices can go back into circulation. The next point, ensuring that all emails and other data are preserved. Email is a big one. So you need to make sure to identify other employees with relevant information and make sure to issue preservation instructions to those employees and disable auto delete on computers and any other relevant devices, and also confirm that backup tapes are performing properly. There's two reasons for this. The first of which is a lot of employees do a lot of bad things on company email. And if they make that mistake, you want to be able to retrieve it. Number two, once you're on notice of potential litigation and discovering a theft certainly puts you on notice, you have certain obligations under the law to preserve evidence. And if you don't do that, it's called spoliation. You'll be subject to sanctions. So that's why you need to take these steps to preserve right away and don't wait on that because the consequences are significant. Next, a lot of this stuff seems like common sense, but you saw some of those survey results earlier. A lot of these mistakes are made. Cutting off employees' access to your trade secrets. Make sure they can't access the server. Make sure they can't access company cloud accounts. Make sure they don't come back into the office to access physical files. If they say they're coming in to get personal items, make sure someone's with them to ensure that they're not touching anything belonging to the company. Photographing and taking inventory of the workspace. It's not only about what's there, perhaps what's more significant is what's not there. If you have a sales employee and, there's nothing there relating to the largest customers that employee was responsible for, that's a red flag. Interview and review emails of other employees. You want to know, who was involved, who knows something. You want to find out if it's just that employee left or somebody else. And, doing those interviews and looking at emails of close colleagues, that could be one way to figure it out. Now, again, all of these steps need to be taken as soon as possible. You need to do that because you need to find out what's been taken. You need to make sure that no one else is involved. You need to, prevent future theft. And by taking these steps, you could cut it off. You could stop the harm from continuing. But just as important as all of this, mitigating damage and ensuring that things don't get worse, is that you have to be assuming that this will end up in court. And if a court looks at what you did and determines that you didn't take reasonable steps to protect your information and that you didn't act quickly in doing it, then a court's not going to be giving you the type of relief that you need. And that relief is your injunctive relief. Because that's the way to stop the bleed. That's the way to ensure that something doesn't end up in the public domain. And a court will look long and hard at your policies and your procedures and what you did when you discovered that theft to make sure that you acted reasonably and with all appropriate haste. All right, so that's all I have today. And I'm gonna, I see there's a few questions I'm gonna answer, but before I do that, I just wanna thank you all for participating today. This is a topic that I really enjoy speaking about. So again, I appreciate you, and I'm just gonna take a look at these questions real quick. All right, I got a question. Is there any avenue for the protection of trade secrets for international business, i.e. sending a formula to a contract manufacturer in a foreign country? Yeah, I mean, there's some protection. What you're going to want to do is have certainly a non-disclosure agreement. You want to have everything in written form. I would include in any agreement a non-disclosure or what have you, a choice of law and choice of venue provision. So in the event that contract manufacturer in a foreign country ends up violating that non-disclosure, you could hold them accountable here in the States. But that's going to be the way to do it. You're going to have to do it through contract. Let's see. All right, I got a question. In New York State, I've heard that non-competes are difficult to enforce. They are difficult to enforce. You need to make sure that whatever you have in place is consistent with the law. And that's going to be the issue. You don't want to overuse them. If you use non-competes for your most valuable employees, those who have broad access to your information, and you use them or you construct your non-compete in a way that's, reasonable, not, doesn't extend any further than it has to geographically. It's not, 2 or 3 years, it's only 1. Courts will enforce them. I've gone to court numerous times and enforced non-competes. But, if you use them for all of your employees, regardless of their position, and you recycle old agreements, no, a court's not going to enforce them. A court's going to look at what you did and determine that you're not using them for legitimate purposes, but instead are using them just to restrict competition. And that's why you want to use a non-compete in a sparing, I wouldn't say sparingly, but you want to use them. You want to be careful with how you do it. Again, it's just you want to make sure that your key employees are locked up and not try to use them for everyone, because that will be held against you. That will be evidence of the use of non-competes in more of an abusive manner, and instead of trying to protect legitimate interests under the law. Baseline cost for a trade secret audit, it's going to depend on what you need. I mean, if you want everything to be done everything under the sun, it's going to be an expensive proposition, but that's not what every client needs. Some businesses need an update on agreements, and just a few policies in place, an update on an employee handbook, and something like that is going to be more affordable. But if anyone wants to talk about a trade secret audit, give me a call. There's not going to be a charge for that consult, and we can walk through what it is that you need done, and I can provide you a cost estimate. But the thing about a trade secret audit, it's not, a off-the-shelf type thing. It's customizable. It's going to depend on each particular business and their needs. So that's why it kind of requires that sit down or a telephone call to kind of walk through what it is that you do, what you already have in place, and what you may need. And then we could come up with something and figure it out from there. Okay. And I think I see here, can we refer back to the presentation via recording? Yes, we actually, put our recordings on our website. I don't know if you do that, Peter, with stuff that's done for the BNMA, but we can make sure that at least at some place, this presentation is available for later viewing.
Yeah, heretofore, we haven't done that, Brad.
Okay.
But, welcome the opportunity for the member who requested that.
Okay. And we'll have it somewhere. So, Bill, if you want that, we go ahead and make sure you have access to it. All right. Well, I think that's everything. Again, thank you all for your time today. I very much appreciate it. And certainly if you have any questions, feel free to call or email me. My information is right here on the slides. And I guess enjoy the rest of your day. It looks like a beautiful day, at least for the next couple hours.
Or in Buffalo, 15 minutes. Brad, thanks so much. This is a very complex topic and fraught with, from what I can see, potential potholes. So, some with your expertise, I'm really grateful that you shared your gift here today. And I encourage anybody out there who has questions or doesn't know how well they're protected, give them a call. He's been a great partner as here in the BNMA. Brad, thanks again, and Kathy and Kate, thank you for your help in getting Brad and I out on the stage here.
Yes, thanks everyone.